Hello, everyone. Welcome to Court with Krissy. Time for an update. Remember the defendant that drove drunk to the cop shop? Who could forget him or his attorney? Well, they're both back. And today it's time for sentencing because apparently a jury of his peers found him guilty at trial. As always, if you happen to miss the first appearance, link will be in the video as well as in the description. I hope you like it. Court with Krissy is now in session.
We're ready to go on the record now. We'll call the case of People versus Michael Marvin first. This is file 45339. Mr. Sherman, when your client comes up to the podium there, please. If I can have counsel, please, your parents.
You're a cook on behalf of the people.
James Sherman for Michael Marvin.
Time set for sentencing this matter. The record should reflect Mr. Marvin is present here in the courtroom today. Mr. Marvin, have you had an opportunity to go through the pre-sentence report? Yes. Mr. Sherman, about that? Yes. Okay. Mr. Sherman, are there any additions or deletions or corrections that report?
No, Your Honor.
Are there any challenges to this guidelines?
No, Your Honor.
Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this warrant?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, the court sat over the jury trial, is familiar with the facts. Mr. Marvin, has some issues. He has done, I probably should have revoked his bond months ago, to be honest with you. He has continued to miss tests even after the PSI. I got a message yesterday that he had missed 3 more tests. He hasn't done great on bond. I think the recommendation is appropriate. His guidelines are high, but they're high because of, his history and because of the charges, and because he has the concurrent charges. I asked the court to follow the recommendation. Thank you.
Thank you, Mr. Sherman. Anything on behalf of your client today?
Yes, thank you, Your Honor. As you know, Mr. Marvin's here today for his sentencing after he was found guilty by jury trial on 3 felony counts, 2 resisting and obstructing a police officer and 1 operating while intoxicated. His 3rd offense. I would advocate this court, I would request this court depart from the recommendations of the department to the extent that they recommend any term of incarceration. While the charges here that Mr. Marvin was found guilty on are severe, they do stem deeply from a context of alcoholism. Clearly has a problem, as the people just pointed out. I don't think it reflects a pattern of violent or criminal behavior, more so a crisis and substance abuse issue that needs to be treated. While alcoholism did contribute to the actions Mr. Marvin took that led to these charges, he has a motivation to seek rehabilitation even months before now, or at least a month before now. Mr. Marvin and I have went back and forth looking for potential AA classes, counseling sessions, other rehabilitation services through Northwest Michigan Community Health Center, which actually waitlisted Mr. Marvin for reasons he can expound upon. But he does have a motivation to change in the future. He's remorseful for what he's done. You were here for the jury trial and you were able to observe Mr. Marvin's demeanor, even the things he said during the trial. He was respectful and polite, even before the trial, during his pre-trial appearances. He has had some issues on bond, but as the state pointed out, only regarding testing for substances. Mr. Marvin's a 44-year-old veteran. He's overcome substantial obstacles, including obtaining his GED and solely supporting his family, his wife who's here today. And despite his past criminal history, his current circumstances, I believe, present an opportunity for reformation. And support from his family and friends and the stability of his living situation, I think, further bolsters a probationary sentence over any term of incarceration. As the state pointed out, Mr. Marvin does have pending criminal charges in Maryland, but I would point out that those criminal charges are pending from 2004. I'm not sure what they're doing with those, but it surely doesn't look good for Mr. Marvin, but it does bolster his argument for a probationary sentence over any term of incarceration, especially a 12-month term, because he will surely have to resolve that matter in Maryland and appear soon, and he plans to do that. So I think it will be a lot easier for him to appear and resolve his matter in Maryland if he's not incarcerated, of course. As I pointed out, the department recommended a 3-year probationary sentence, but page 2, condition 15, number 15 of the recommendation recommends the first 12 months to be served in the Crawford County Jail. Again, I asked the court to depart from that recommendation to the extent only as to number 15 on page 2. 4 factors that I know the court must consider when sentencing Mr. Marvin, such as protection of society. I believe strict compliance with terms of probation will protect this society in the same way as if Mr. Marvin was locked up. It's better for him to have a probationary sentence so that he can rehabilitate himself, reduce the risk of future offenses, which would ultimately protect society in the long run, not just for 12 months. Obviously, Mr. Marvin must be punished. As this court knows, the punishment must be proportionate to the crime committed. And given Mr. Marvin's efforts thus far, his current circumstances, a probationary sentence would be just and fair, giving him an opportunity to acknowledge what he did wrong and at the same time working towards positive future behavior. Lastly, and probably most important, deterrence from doing this again. It's just one factor to consider, but a probationary sentence would accomplish deterrence for Mr. Marvin. Engaging in the acts that led to these current convictions, reinforcing the seriousness of the acts that he did, and giving Mr. Marvin an opportunity to address his mistakes, rather than having the opposite effect, which I feel incarceration will do, further entrenching him in a cycle of criminal behavior. We don't want to see, Mr. Marvin does not want to be here again. I don't want to see Mr. Marvin here again, and nor does this court. So in conclusion, I respectfully request this court to impose a sentence of 3 years probation for Mr. Marvin with no term of incarceration. I believe this approach not only aligns with rehabilitation and the goals of this court for that, but protects the community and acknowledges, it allows Mr. Marvin to acknowledge what he did wrong and work towards a better future. I guess lastly, I'll just note on a kind of like a side matter that I thought it was odd that there was a term of incarceration as a condition for probationary sentence, because probation inherently is something other than incarceration. I think Mr. Marvin has shown through compliance, substantial compliance with his bond conditions, that he can do the same during a probationary sentence, complying with conditions without the need for incarceration at all, which is what a probation contemplates. That Mr. Marvin can prove he can be out in society, follow the rules without being completely isolated from being a productive member of society, as he is now. Not only that, but he, as I pointed out, is the sole provider for his family. Mortgage, other expenses that are solely paid by Mr. Marvin, and his VA and SSDI benefits that he stands to lose if he is sentenced to any term. I do think the first 12 months, whatever sentence Mr. Marvin has would be the most important. I don't think that should be spent behind bars. Rather, he should be working towards the services he's already attempted to participate in. I have supporting documents here that Mr. Marvin's provided me to show some of those efforts, as well as 2 support letters from his wife and his stepmother Grace. If I could approach and provide the court those to consider.
Yeah, Ms. Coke, have you seen those?
Yeah.
Ms. Coke, take a look at those.
Yeah, approach.
Yes. Okay, I've had a chance to review those documents. Did you want those attached? Yes,
Yes, right.
Mr. Marvin, anything that you wanted to say to that?
I've been an alcoholic for 20-something years. And by that, I don't mean that I've drank every minute of that. I have periods of time, 7, 10 years, 13 years the first time, where I'm fine and I think I'm doing good, and then I get pulled down by something. And me and my wife have decided that I just don't need to drive, because I do good for 7, 10 years and then I have a bad moment and that's it. It's just not worth it to me anymore. I could have dealt with everything way better than I did. I got myself paranoid, frustrated, and I didn't know how to deal with it. And I only had to wait a half an hour for my wife to get home instead of making the decisions I did, and they were wrong. I don't believe, sir, that when I said that I had a panic attack, I don't believe that I wasn't saying that the police caused that, sir. I have them daily. You know, it's part of my life, and when I'm doing something that is stressful, that is when it is most likely going to appear. And I just want to reiterate, because I said that before to the prosecutor, that I didn't believe that those police officers were bad in any way, or that they did anything wrong to cause it. It's my problem. I don't blame that on them. I understand that, sir. I just wish that I would have dealt with things better the first time. The first incident in July, as soon as that happened, sir, me and my wife got right on the phone and tried to get me into the VA here. It has taken us until literally yesterday to get in. I got my blood work done yesterday and I have an appointment on the 14th. That is where I have found my help. When I said that I've been an alcoholic for 20-something years due to the reasoning behind the disability, sir, I didn't talk about it for 18 years. I didn't even try to get help until 6 years ago. And I got into the VA, and that was by accident. I was sent by the court to see a counselor. And she told me, she said, you know, I don't think that you need, I think you need to deal with the underlying issues. And she helped me get a hold of the VA, where I switched a lot of medications up. I'm now on 1 medication. I was on 7, including Xanax, sleeping medications, everything that was given by a civilian doctor. When I got with the VA, they got me on the right track. I do think that I need another evaluation for medication. My wife has taken over distribution of my medication, because when I get depressed like that, I miss days, not intentionally. But at the end of the week, I'll see that I missed 2 or 3 days. So she's taking over that. We have I messed up. You know, that's all there is to it. I let myself get in my own head. My wife calls it a rabbit hole. You know, I get fixated on things, and I get paranoid, and I can't get them out of my head, and I can't let them go. And I'm not usually like that, and I'm strong, I'm intelligent, and that's what pisses me off. Excuse my language. Say, I do so good for so long, and I just think that I'm okay, and I'm not. And with this was my fault. When we moved, I was doing really good, and instead of moving the VA from Traverse to here, I didn't, because I was in a good spot, and I didn't realize until, like I said, a year ago that I needed it. And at that time, you know, it was too late. Unfortunately, I got in trouble before I got in, but that is what I believe that I need, is the counseling that I get there is specialized for my type of PTSD. I believe that I need an additional medication or a uppage of medication. I've been on it for 6 years. It's a very light medication to begin with. And I just don't believe that it's having the same effect anymore. Like I'm very bouncy, as you can see. I don't have any more to say, sir. I would like to say that, you know, I got a service dog and training, and I love my animals and I love my wife, and that's all I have. You know, when she met me, she pulled me out of a lot of bad things. And I know that looking at me right now, I'm not in the best place, but I'm telling you, I've been a hell of a lot worse. I fought to get here, to get us a house and to start over. And I tried, sir. And I believe that the fact that I was detoxing, you know, when this happened, sir, shows that on my own initiative, I wanted this. And you know, that was something that I was working on, and I wish that I would have been able to finish it before that day, but I wasn't, sir, and I made mistakes. That's all I have to say.
All right, thank you. I read through the pre-sentence report. That gives me a lot of information about you and your background based on what's in that report.
Yes.
Obviously, I presided over the trial. I heard all the evidence against you. And so I'm fully aware of all the facts in this case. And then, of course, there's more information in the pre-sentence report about the issues that you had while you were on bond, as well as your outstanding issues in Maryland. So, you know, there's a couple of things I guess I would point out that stood out to me as I looked at all the facts of this case. Number one, based on the report, you got 31 positive PBTs, 36 missed PBTs while you were on bond, and that's just as of the time of the writing of the report. This code indicates there's been more since then. So, to the extent you're saying that you have control of your problem, or you're trying to get control of it, that doesn't show to me at all that you're trying. It shows to me you're just continuing to do what you've been doing. The fact that you're, you know, the documentation about seeking out help, maybe you've taken the first step to seek out help, but you haven't gotten any help yet. You haven't been going to any AA meetings. I don't think there's any reason why you couldn't have been doing that during the pendency of the case. Typically at sentencing, people bring me sheets of their AA attendance that they've been doing. So you haven't been doing that. So, you know, the claim that you're trying to get a hold of this, or you do have a hold of it, to me is just completely untrue and meritless, which kind of fits in with your entire position throughout this case and your testimony at trial, which was clearly untrue. To tell the truth, you sat here and told a story that wasn't supported by any of the evidence and was completely unbelievable to me and to the jury, obviously. So I think you're just, you know, you're fooling yourself, first of all, and I think you're trying to fool everybody else, but none of the things that you're saying are backed up by any real action. You've got some charges in Maryland that have been outstanding for 20 years. Yet that somehow now, by probation, somehow go back to Maryland and now answer for those charges. It's if you were going to answer for those charges, you had 20 years to do it. And I suspect if you were ever to go back to Maryland, they would arrest you if you were there. You would have to answer for them. That's why I suspect you haven't been back there. So, all of those things are factors which, in my view, do nothing to mitigate your case or convince me that any lesser sentence should be imposed at all. And that's to say nothing of your actual actions in this case, which was to drive drunk to the sheriff's department and then confront employees at the sheriff's department while you're under the influence. You put yourself in danger, you put everybody else in danger coming to the sheriff's department that day. And so for all those reasons, I mean, I think a prison sentence could have been argued for here, wasn't argued for. And I do think the recommendation is appropriate given all of the circumstances. And so I am going to follow that recommendation. We're going to be on probation for 3 years, which is a lengthy period of time. And I'm going to tell you right now, based on what you did on bond, I'm not holding out a lot of hope that you're going to comply with probation. And if you don't, what you need to understand is the next step is prison. So if you are going to get things in line, now's the time to do it. And I understand that you've got some underlying conditions, and I think those are valid, just based on what I saw at trial and next interview. I have no doubt that you have legitimate underlying conditions that need some treatment. But none of those conditions excuse the lying, excuse not complying with bond. You can do all of that with those conditions that you have.
May I speak up?
So none of those are an excuse for that.
May I speak on the list?
You've had an opportunity to talk.
Yes, sir.
I didn't stop you. I had to say everything you wanted to say now tonight. So I do think you have some underlying conditions, but you aren't doing anything really to treat those and help those. Really, you might think that you are, but based on your behavior and circumstances, to everybody else looking at this from the outside. So the court is going to place you on probation for a period of 3 years. The court is going to adopt all the terms and conditions listed in this report as the terms and conditions of your probation. The court is going to order that you serve 12 months in Crawford County Jail. You do have credit for 20 days served. The court is going to order restitution in the amount of $125.01 for OUIL testing reimbursement pursuant to statute. Crime victims assessment of $130, court costs of $325, a $204 state cost. And then while you're on probation, a supervision fee of $30 per month. You do have the ability to seek an appeal of this sentence, and Mr. Sherman, on the table there, there should be papers. Have Mr. Marvin acknowledge that he's received. And for the record, all those sentences to be served concurrently.
Your Honor, Mr. Marvin's had a chance to review this.
He gets one of those copies for his records, and then he just leave the rest on the table. He needs to, there's a spot on there for him to initial and acknowledge receipt.
Oh, yeah. Other copies. No,
Yeah, and then move to the officer.
Thank you, Your Honor.
People versus Gold, Wilson,